You each will have 15 minutes, but you as the appellant may reserve up to 5 if you so choose.
Okay.
You may proceed.
Thank you. May it please the court, I am Attorney Angela Killy on behalf of appellant mother in this proceeding. The question that I did want to address with the court today is actually not part of the brief or the arguments that were made. When this case began, this court questioned its jurisdiction via orders from the magistrate in regards to whether or not it had been filed in a proper time frame under the appellate rules. That being the case, I did file a response and was advised that it had been provisionally accepted. So I wanted to give the court opportunity if there were any questions as to whether or not it's appropriate. In this particular instance is a case where the mother came to the juvenile court on July 30th for a June 26th order requesting counsel be appointed and an appeal be had. I was appointed by the court. I did file it on July 31st, the very next, same day that I was actually appointed.
There is saying it was filed outside the 30 days. I can't talk today. I apologize.
It was, Your Honor. It was, and this court had requested that I research whether or not it may fall into the tolling provision of the statute. It does appear as though the practice in juvenile court is that they mark next to the CC at the end of the order. The clerk signs off, initials it, what the date is that service actually took place. In this instance, it is showing that it was served on the same date that the journal entry was filed, which is on June 26th of 2014. I would note for the court that service was had on the attorney that mother had at the trial level as opposed to directly to mother. And aside from that, in regards to jurisdiction, I appreciate the fact that we are a couple of days outside. I just would like to point out to this court that there have been cases decided, for example, in Ray and R, and I'm going to mispronounce this, Datuche Bank v. Taylor in 2011, where this court has been known to say a case should be won on or lost on the merits as opposed to on procedure. I'm going to ask the court.
The only problem is we have had jurisdiction to say that to begin with. And the Supreme Court has just said something that I've advocated for years for is a delayed appeal in these type of cases, but unfortunately the Supreme Court has just said that that's not going to be warranted or not allowed. So.
And I would agree, Your Honor, that this doesn't fall into the delayed appeal provisions. I did review that on behalf of my client. The only argument that I would make would be more of a policy perspective that when we're dealing with something in regards to child custody that's so serious, to ask the court to give consideration to an extension. I can't cite any statute or authority to support that.
Well, go ahead and make your arguments on the merits.
Your Honor, in regards to the merits, unless there are questions from the court on the briefs, I would just submit it on the brief.
Thank you very much. Thank you for your candor and addressing the issue with the court this morning. Thank you.
May it please the court, Helen D. Martino on behalf of the Summit County Children's Services Board, the appellee. The agency would echo what Attorney Keeley said as far as the jurisdictional issue. It does appear that it was out of time. I know the cases have been, especially with the delayed appeal, that it's not going to be allowed. So I don't believe that this would be jurisdictionally appropriate. However, since it is such an important issue regarding custody, if this court was going to carve out some type of an exception, I don't know that there's a provision specifically that prohibits it, but I don't believe that there's anything in place that per se allows it either. And with regard to the merits of the case, I would rest on the brief as well and just note that in this case, mother has not complied with her case plan. She's had more than 14 addresses since the case started. The agency had difficulty trying to get in contact with her. There were phone numbers that weren't working, emails that weren't working. She failed to provide leases. So it wasn't a matter that the agency did not utilize reasonable efforts or did not try to help mother with the case plan. This was a mother who was essentially addicted to alcohol. She admitted to using up to 1/3 of a gallon of straight liquor 2 times a week, using marijuana religiously. So this was a woman who had not engaged in the counseling and the substance and alcohol treatment that she needed to be able to make the decisions to be able to care for her child. The agency did set into place the provisions for her to get her evaluations and asked her to get the counseling so she would be able to remedy the conditions that cause the child to be removed, and she failed to do so. If there are no other questions, I rest on free.
Thank you.
Thank you, Your Honor.
Counsel, you didn't reserve any time. Do you want to say anything?
No, Your Honor.
All right. Counsel, thank you both for your presentations. The court will take the matter under advisement and issue an opinion that will be sent to both sides.
Thank you.